All right, you are recording.
All right. I will call the board meeting to order as the vice chair, and recognizing that Janet is in attendance as our chair, but I will be facilitating the meeting for her at this time. I would like to do a quick roll call. Sarah Had, present. Brooke?
Dingledine, board member present.
Kirsten?
Kirsten Sultan, present.
And Janet.
Janet Hurley, chair, present. I'm quite under the weather and I may even turn off my camera so you don't have to watch me hack away as we proceed. Thank you.
I'll say
All
the
right.
same.
Well, take care.
Unfortunately.
Oh dear. All right. It does not appear that we have any public in attendance at this point. We can come back to public comment at a later time. We have the next item is discussion of potential legislative proposals. I think we have a number of bills that we are going to ask our council to walk us through in executive session. Those being S 325, H 727, possibly S 323 and Act 174 process reforms, as well as wood products language. Is there anything else that people would like to add to that list? All right. I think we are going to ask for a motion to discuss this as well as appeals enforcement and attorney-client privilege in executive session. But before we go into that, is there anything from board members? We had also held this as a possible time for someone else to attend and speak to these matters, but no one has showed up yet at this point. So,
Sarah, I
Yes.
heard from Claire McElvaney of the
Same.
Department of Public Service, and I suggested that we could loop her in when we discuss the 174 changes, the proposed 174 changes.
So she said that she was not available today, but that one of her
okay.
colleagues
And
was
Marvelous.
possibly.
Okay.
And said absolutely and could attend, state something, but to what Janet said too is we could circle back to DPS with our questions as we develop them. So for Kirsten, I'm happy to entertain a motion for executive session when you're ready, but Brooke, oh, sorry, Kirsten first.
Oh, well, I'm happy to make a motion if that's what the board is ready for. The board needs to discuss pending and probable Act 250 appeals and enforcement actions. Are we not ready for that?
Nope.
Including the aforementioned pending legislative topics as identified by Vice Chair Sarah Had, and to have confidential attorney-client communications on these matters. I move that we find that premature public knowledge of these matters would place the board at a substantial disadvantage and the board enter executive session.
Thank you. Brooke?
I do so with the caveat that I am not aware of enforcement or litigation matters that are needing to be discussed in executive session. So unless I'm wrong, I would like to modify it to.
I think there was an email just before the meeting from Jenny potentially on a legal matter. But Jenny, you're in attendance. Maybe you could notify.
I don't have anything to share on enforcement or litigation issues, but I would like to speak with you guys in executive session about the legislative discussion.
Okay.
Okay, I will modify the motion to remove reference to enforcement, appeals, and litigation. Sorry, it was on the agenda, so I perhaps misunderstood.
Right, and there is a matter that Jenny just sent right before the meeting, but if Jenny does not need to discuss that, then Quirk, are you accepting of the amendment to the motion?
Yes, and I would, so long as it's based on the premature public knowledge would be prejudicial to the board. Yes, I would
All
second.
right, so we have a motion and a second as modified. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Looks like we have 4 in favor with Alex absent. All right, we will enter executive session and Rachel, I will message you when we're ready to come out and I'll see you guys on the other side. Thank you.
Mandy, I haven't.
Okay.
Looking for Anne. I'm gonna try to call her in.
We're back and we have nothing to report from executive session because we were notified that there was a person that wished to speak as public and wanted to come back out immediately to allow that to happen. So Jenny, are you making contact with that person?
I'm trying. Rachel, is there someone in the, she says she's in the waiting room on Teams. Sorry.
There's no one in the waiting room.
Let's,
Okay.
I can forward her the address here, the meeting link.
Someone is calling her in, it looks like.
I was
Oh, great.
trying to.
Oh.
All
Seems
right.
to be successful, hopefully.
Welcome, Ann. We just called you in.
Thank
We're
you.
not quite sure what waiting room you were in, but Glad we found you. We exited executive session to come back to give you an opportunity to speak as a public to be heard on legislative matters. And so welcome, and please share with us what you'd like. And I think we might have a question or two for you.
Great. Thank you so much. And I'm not sure. I was out there in somewhere in the purgatory of cyberspace. So I appreciate you calling me in and taking the time today. And I won't try not to take up too much of your time here. I'm Ann Margolis with the Department of Public Service. We have some proposed legislation. We've shared it with Chair Hurley, some different versions kind of over time. And I don't believe that there is actually really much in there that would implicate, if anything at all, that would implicate any change on your end for your process at the LURB. But this is really just work that we do on giving determinations of energy compliance for the energy plans that are part of regional plans that this is required as of Act 174 of 2016. So, 10 years ago, the legislature passed this law that required the Department of Public Service to give affirmative determinations to regional energy plans that met a set of standards that are released by the department to be consistent with the State Comprehensive Energy Plan. So we've been doing this now for almost 10 years. Initially, we kind of expected these plans that we'd be updated on a regular regional plan cycle, about maybe every 8 years or so. And we have seen over time that it's been a little bit more frequent than that. And now with the inception of Act 181, we are seeing these plans a lot more frequently than we had anticipated. And we didn't, we were never staffed or given kind of any resources to actually implement Act 174. So we've been doing this, borrowing existing staff from doing things like reviewing utility rate cases and reviewing utility integrated resource plans. So anything we can try to do to streamline that process and have it be more efficient. We already had some ideas for how to do that prior to the inception of Act 181, and then Act 181 came along and created not only a new process for us to kind of input on your review process of regional plans, but required us to touch the plans for Act 174 review much more frequently, even if we had just reviewed them, because every time they're adopted, we have to go through a new review process with reviewing the drafts, as it's very similar to kind of your process, but just on the energy plan side. So reviewing the drafts, holding a public hearing, reviewing the plan once it's adopted for consistency with our energy planning standards, and then issuing the determination of energy compliance. So we have proposed some legislation that now the House Energy Committee is reviewing. They're not that familiar with Act 174, so it's been a little bit of a process to kind of orient them to what Act 174 is. We've testified, your chair has testified, and then Catherine Dimitruk from Northwest Regional Planning Commission has testified as well. And it's our understanding all of the RPCs are in alignment with and supportive of this language, which the primary things it would do would align the timelines so that when the Regional Planning Commission sends its plan to you all for Act 181 review, sends its draft plan and then its final adopted plan, they're also sending us simultaneously their Act 174 energy plans for review, so that it's a similar timeline, but it doesn't change anything on your end for what you all have to do for your review. It also, in terms of the hearing, rather than having the Public Service Department do a separate hearing on the adopted plans, it would actually have the regional planning commissions solicit feedback on their plans' consistency with the energy planning standards when they do their 2 hearings that they have on their plans prior to adoption. We think that's more effective because, for one thing, once the plans are adopted, it's very hard to make changes at that point. So we think, it's a public hearing that can't really create much effect in terms of changes in those plans at that point. it's much more likely that if the regions are getting feedback on those draft plans during those public hearings, that that's the point where they can actually make substantive changes. And then they would report to us when they submit their plans for a determination of energy compliance on a summary of all the comments that they heard in those hearings and how they've responded to those comments. It also allows us to give provisional determinations to adopted plans because we have this issue where there's a gap in the coverage of certification that we would issue. When we issue it, it extends to the expiration of the plan. And the plan expires when they've adopted a new plan, and it takes us 2 months to review the plan and issue a new determination. So there's this kind of unprotected period when the plans wouldn't have as much say in a Section 248 proceeding before the Public Utility Commission. And then it also allows us to give extensions of determinations for plans that have not updated their energy plan, but have been adopted for, readopted for other changes like Act 181. That's what kind of we're going through right now, where we're seeing plans that we had maybe just a year or two ago given a determination of energy compliance to, then they have to be readopted to meet the Act 181 requirements and go for LURB review. And we're having to review them again because they were readopted and we had just seen them. So we have to go through all that process and time again. So those are our main changes. It doesn't require any changes for the LURB and your process, but we wanted to make sure you were kind of aware of what we were proposing and answer any questions you might have. I think you have the language. So yeah, just let me know what you think, or if you have any further changes or recommendations for us.
Thank you so much for that overview. And we do have the language that came in. I'll take any questions from board members first and then staff. Do you have any questions from board members? Brooke?
Question, I just want to make a comment about the importance of enhanced energy planning approvals, because there's an impact that's important, not within Act 250 per se, but it does provide municipalities with more say. The terminology is substantial deference as opposed to due consideration of their positions. So, and their, so this is a very important thing. Not to mention, obviously, the enhanced energy aspect of the regional plan itself. So it sounds like it makes perfect sense, and certainly the duplication of the hearing process, I am fully supportive of eliminating that, so long as there's still due process on all the issues. So I think it makes all the sense in the world, and I'm certainly supportive of it. And this is an important aspect of regional plans that are not directly under our approval process, but yeah, we should cooperate in every way we can.
Thank you.
Kirsten?
Well, yeah, similarly, I don't have questions per se, only to mention, thank you so much for giving all that context and background, because we did receive all the language, and when I was going through it, I couldn't really myself decipher how this might impact the LURB's work. But knowing, the sort of broader context and the different elements from your standpoint, so, it's just helpful. So thank you. I don't have any known concerns or anything. It sounds like good alignment and straightforward, and totally agree. Makes sense to consolidate the hearings, the public meetings.
Thank you.
All right. If there are any other questions or comments from board members, do we have questions or comments from staff? Well, Jenny's hand's up first, but Janet.
Janet first.
Oh, okay.
Janet?
Well, I just, for the record, want to say that I fully support this, and it shows how important this pre-application processes, where get anyone who's interested in these regional plans to provide comment up front before the regional planning commissions go through the adoption process. And I'm perfectly happy to include to explicitly include the Department of Public Service in this process.
Thank you.
Thank you, Janet. Jenny, you had a question?
Yeah, and forgive me if I'm behind the actual board members and their sophistication on this one, but I just wanted to walk through the 3 proposed changes to section 4348 very quickly, just to make sure I understood them. As I see it, the first amendment is in 4348B, which is the pre-application process. So there, if you can just confirm with me, the DPS is seeking that the Regional Planning Commission submits their draft to Department of Public Service as well as alongside the Land Use Review Board, right?
Yeah, at the same time. Yeah, trying to align those timelines. We don't have a formal draft review process like you all have built in. We basically ask the regional planning commissions to submit their drafts to us so that with their draft standards checklist so that we can flag any issues and they have a chance to address them before, the plan is finally adopted. So we're just trying to make sure that while they're at it, submitting their draft to you under your more formal process, they're also submitting it to us at the same time.
Okay. The last sentence of section B, the existing language, talks about how the board shall coordinate with other state agencies and respond. Is there anything that we can do in that part, like under that existing authority, to assist here?
That's interesting because right now what's happening in effect is we've communicated to the regions we'd like to get their plans at the same time, their draft plans when they submit them to you. And that is, I think, happening or starting to happen more smoothly. And you guys send to us the notice of the plans and ask for feedback as part of your, outreach to other state agencies and stakeholders. And we end up sending comments back on just the couple energy related standards that you all have, which there is a little bit of overlap there. I guess just I'm not sure exactly what it would be without you all taking on some of our responsibility, you know what I mean? To like, I don't know that you would want to take on having to require that the draft plans be sent to us and include our standards checklist. And I mean, if you wanted to, that'd be great. But I know you have a lot on your plates as well there.
Yeah, no, I appreciate the way this is drafted because as far as I can tell, it doesn't actually change any of what the board's requirements are. But I mean, I guess I'll just flag for everyone that we have our own sort of procedures related to how to review this, and maybe if more support is needed, that's a place that we could all work together. So then my second question, or the second part addition in 4348 comes in 4348 section D subsection 2, which is the at least 30 days prior to the first hearing, the Regional Planning Commission shall provide its municipalities with the description. The Regional Planning Commission shall, if seeking an optional determination of energy compliance, solicit feedback consistent with 4352, and that's going to you guys.
Yes.
Is soliciting feedback different from them giving you a copy of their plan for review?
This part is meant to say that the Regional Planning Commission, when it's doing its hearings on its regional plans, that it's specifically asking for feedback on consistency with the energy planning standards at that time during its hearings. And then later on, there's some language that says when the region submits its plan to the department for the determination of energy compliance, it submits a summary of what it heard during those hearings as part of its submission to us.
Okay, and that's the H1 language?
Let's see, I'm in D2.
Yeah, that was D2. And then there's further, the last bit of
Oh, yeah.
language in 4348 is under H1, which says
Yep.
that when they submit it to
Yes.
H1 is for our like actual regional plan application, not the pre-application.
Yep.
So, okay, I just wanted to confirm that you guys were hoping to essentially see the pre-application, the application, and have your opportunity for your hearing to comment with the regional plan process. If I might have
Yes.
misarticulated that last one.
Well, yeah, we're hoping we want to get the draft with the draft standards checklist, and we want to so that's the draft regional energy plan, and then aligned with your timeline, and then we want to see the final submission of the adopted plan with the final checklist at the same time you get it, and part of that submission to us includes the public or the comment summary that the regions heard during their hearings that they held on their plan overall, and everything on the plan, both energy related and Act 181 related and all the other things that are in that plan.
Great. Okay, I was just confirming all that for myself and
Okay,
appreciate
yeah.
everyone's patience. Okay.
Yeah, no, thank you for those questions. It's good to get this. It's a lot of process. I mean, when I saw Act 181, which was way too late I wasn't paying, that much attention when it was passed, and looked at it later and said, oh, this seems a lot like Act 174, but for all the non-energy pieces. So I know Catherine's here and can comment from an RPC perspective, but I can imagine that's it's just a lot with the two processes, and hopefully this makes it a little bit more streamlined and cohesive without completely merging the two, which maybe is an option down the line, but it seems like a baby step in that direction.
All right, thank you, Anne. Any other questions for Anne at this point on 174? All right. Well, thank you so much, Anne, and I very much appreciate you taking time. Sorry that you were lost in the waiting room for a bit,
No.
but
Thank you so much for your time. It seems like House Energy is interested in the LURB's feedback on this. I don't know if you have a next step on communicating with them. That was the only last thing I wanted to mention is it could help us to move forward with this if they heard something sort of more official from you.
Absolutely, and I think just part of sort of recentering some of the folks that just joined us is we had started the meeting and made an opportunity for public comment to have anybody join us. Went to executive session to talk with legal counsel about some of the impacts of the bills being proposed and have those conversations. We're anticipating reporting back out from executive session, and to your point, there might be an opportunity there, but we as a board have to discuss that. So I think I want also sort of frame that in terms of, for all the people that have just joined us, coming back to that public comment session before we go back into executive session. But Pete, did you have something to add?
No, nothing from me.
All right, very good. Well, thank you, Anne. And I'd like to go back to the public comment portion of the agenda before we consider going back into executive session. Would anybody like to speak that's in attendance?
I'm sorry, is this our only chance, or are we part of the potential legislative proposal topic?
So we just had sort of begun the legislative proposal topic and would like to get public input before we go into executive session on that topic. So absolutely, if you have something to share now, please.
Do you want us to walk you through our legislatively or proposed language that we are proposing to the legislature? Is that, sorry, I'm trying to follow to help you in your process. What would be most helpful?
That would, I'm seeing head nods from some board members, and I think I'll also orient you is unfortunately, Janet is quite ill today, so I'm
Oh,
running the meeting even
sorry.
though she's in attendance. So apologize for a little bit of out of sorts here. But absolutely would love a walkthrough since you both have taken the time to attend. And we were given it in advance. So you might have some questions from the board members as well as staff too. So by all means, if you would like to do that, please do.
Okay, Catherine, did you want to start or did you want me to?
I go for it, Charlie.
Sorry, we have not rehearsed our show, but we have done it enough times. So I want to make sure we're all on the same page, so to speak. You have a 10-page Word document that has explanation comment boxes trying to explain the different sections. Okay, excellent. Then just to walk through, and Catherine, you jump in as appropriate. We'll do high level real quick. There's I think probably 4 or 5 main topics in here. And if I could just real broadly touch them, the first couple are about the process for amending and approving regional plans. And so that's just to set that. The next, those are basically on pages 1 and 2. And then from pages 3, 4, and 5, 6, 7 is really, those changes are all very interconnected, even though there's different sections of statute, trying to clean up and clarify and also consolidate the definitional language around our future land use areas in one section, which is 43, 48A. And so any deletions that you see, I just want to preface our conversation saying like that, though that language or that idea is not gone, it's just in one section instead of multiple sections. Catherine, is that fair?
Very fair.
And then the last couple pieces on page 8 is the smart growth definition that was in statute in the old chapter 76A, the designation chapter. I just fell off the table somewhere in the conversions and moving that to chapter 139. But also, as we looked at it, it seemed to make more sense to be tied to our future land use area definitions rather than the designation. So we're proposing to put that into 4303. And then there is one last little thing, which is deleting 24 VSA 4476, which is a remnant of an old process with the Council of Regional Commissions that were set up 30 years ago in statute, but never actualized. So there's one paragraph or one little section there that is still did not get deleted at that time when there was a big cleanup of this, maybe 10 or 15 years ago. And so anyway, we just thought this might be a good time to just clean that up because that section in particular seemed to really set up a conflicting process with the LURB's responsibilities now.
And the only thing that I'll add is that we spent the last 6 or 7 or 8 months with working on this draft. It started much longer. We've been sharing it with Janet and Pete along the way, as well as other partners like the NRC and the Preservation Trust of Vermont and the administration. So this has been a collaborative effort to get to this point.
Yeah, and I think one of the things that we took away from our conversations with legislators, and particularly Senator Watson, who I think is now trying to thread the needle on any changes that happen, was that we are not really trying to advance any policy. We're really trying to clarify. And so, but I guess I'll also say apologies that it's messy with all the definitional things that were in different little sections. So, and I don't know how much time you have, or do you want to go like more detailed, kind of we'll do a walk through the document. You want me to share the document?
So I think why don't we leave it there, because I know we got a copy of it in advance, and I think you might have some questions from board members, and maybe that's a productive use, but appreciate we can come back to that if board members would like that. Do board members have any questions or comments at this point? Brooke?
Only a few.
The sentence, it's the intent that almost every town in Vermont should have at least a village center in which additional housing units are supported. I want to hear about that, because it's something that I think the board has been faced with, the notion of the equity, benefits, burdens, all of the concern about making sure that particularly our rural areas also are treated equitably. So can you speak to that? I don't, tell me what you think about it and whether we should be saying this. I'm not sure if the language is what we're trying to accomplish, but substantively, can you explain to me that notion? Should we, shouldn't we?
Well, I think from those of us that were in the room during the sausage making, this is what we understood the intent to be. And also understood that intent, you know, as we were working as the RPCs, that we should be trying to, it doesn't mean every town, and notice it says almost. So there are certainly situations that have come up. Either a town truly doesn't have anything more than a crossroads, you know, and a town hall maybe, or the highway garage, you know, but so it's not that every town will, but there was an intent here that we feel was important to articulate, that we are trying to map these at least village center in every town that we could. And
I think you summarize it nicely, Brooke, within the context of your question about the equity and the inclusion of benefits from Act 181 in our most rural communities.
The use of the word almost, that's because you don't want it to become like mandatory, or you want to allow municipalities to choose not to have that, or the regional planners.
Well, I think the reality is just what's on the ground. There are some municipal geographies in the state that just don't have a center.
Right.
The town of Baltimore comes to mind. There's some others like it. It just doesn't exist.
The other portion of your proposal that I really like is the removal of the historic center. We have been grappling with that. What does that mean? Must we have something that's historically protected? And then trying to understand, well, how could we interpret historic? Meaning, you know, well, history might be 20 years ago, right? So that's wonderful. I really appreciate that. And I'll leave it there with my comments. Thanks.
All right, thank you, Brooke. Janet.
I just wanted to point out that I think we will have entertained some questions from our legal team in executive session, Charlie and Catherine. So we may want you back after, or you may want to stick around till after we could call you back in when we're back in the regular session.
We can go back into that waiting room. I was getting very comfortable there.
Yeah. And I don't know, it just occurred to me that, yes, there are municipalities around the state. There's Glastonbury in Bennington County, for instance, that, you know, 50 people live in at most, and some of them may be, you know, seasonal. But I do agree that it was the intent in Act 181 to allow for every municipality in the state to have at least one center. And, you know, the almost could be, I hope that it wouldn't be misinterpreted as, you know, not allowing for that should Glastonbury at some point define a little center, you know, or, you know, Buell's Gore or some other, you know, tiny little place. So, you know, I wonder if it should say the intent is to allow that every town in Vermont could choose to have at least one village center.
Yeah, there's probably some different ways to say that, or the opportunity. You know, I think that's what we were understood from the legislative conversation that wasn't really clear in the statutory language.
Yeah, and I think this language has been wordsmithed significantly through the process. And every time there's a suggestion of a new way of saying it, it raises a bunch of different questions. Like the language you suggested, Janet, well, it's not really the municipality's choice because it has to go through the Regional Planning Commission board and then the LURB approval. So it's every wordsmith leads to more questions.
All right, Kirsten.
I have a question that hopefully is straightforward and probably Jenny will be able to explain to us a little bit further in executive session, but Catherine and Charlie, while you're here, it pertains to the strikeout of the following sentence as it pertains to process. The
you tell me which
adoption of an amendment
page
shall.
Are you
shall
on the first
not-
page?
So this is on page 2.
Okay.
Towards the top. Adoption of an amendment shall not change the expiration date of the plan. So what's your interpretation of that? Like conceptually in my mind, that means that maybe the clock is reset every time there's an amendment, like it's the date's moved out. Like how do you understand that this would work?
It's not how amendments work in the context of municipal and regional plans. So when you have a municipal or regional plan, you have the choice of adopting or amending. And when you amend, you focus on a certain section of the plan only. You take your public comments on only the proposed changes, not the underlying plan. And it just changes portions of the plan and it does not reset the 8-year time clock. And
That
so
would be how I would think it should work. And that was consistent with my own general understanding, but why is that being why is that being it's suggested that be removed from the statute?
Yeah, that language is redlined out.
It's redlined strikeout.
Strikeout.
Not,
So like
not
that-
in my version.
not in our version. Yeah.
Yeah, it's underlined in ours.
Oh.
So, sorry.
the copy I
don't know.
received, it's a redline strikeout.
Kirsten, you may be looking at my notes, which I'm hoping you will not share with the public. The attorney work product right now.
I think we just found the source of that confusion. Yeah, that is.
Is it
that's,
team-
My
It does
eyes are
not
closed.
eliminate that language. It just reorganizes that section. You'll see it's under what I'm proposing. It's subsection 2.
Okay.
Yeah, we should probably look at the version we sent if possible.
Yeah.
Yeah.
Thank you for the clarification.
Thank you for that clarification, because that makes your question make more sense
Yeah,
now.
sorry, you're probably like, what's she saying? Okay.
Version
Right.
Yeah,
control.
I was confused too. I didn't realize that we had a red line version from Jenny. Thanks, Jenny, for pointing that out.
So I have a couple of questions, but Brooke, why don't we go back to you first?
Just on that point, I assume since you've been working on this language a long time, you feel it's necessary, because I'm thinking it's kind of belts and suspenders, because that is how the law operates generally, but you think it's important to put it in this section as well?
For clarity, yes.
Yeah.
Yeah.
No worries, thanks.
All right, I have a couple quick questions. The first is on the 4476 process that is proposing to be eliminated. Is there any potential that could still need to happen at all? Any due process concerns with eliminating it?
No,
No.
to our knowledge, it's never been used, and it's just an artifact of an old process that seems like it's also in competition with your process.
And then the second question I have is switch gears a little bit. You came in at the tail end of the 174 discussion the board was having, and I'm not sure if you've had a chance to review DPS's draft on enhanced energy. If you had any comments under that.
Yeah, DPS actually collaborated with us as part of developing that language, and I did testify yesterday in support of it with the House Committee on Energy and Digital Infrastructure. So the RPCs, Charlie and myself have reviewed it. a few other RPCs as well, and we're all very supportive.
All right, thank you. Any other questions from board members? Any other questions from staff? Any other questions from anyone?
Well, I only just hope that Janet feels better soon.
Absolutely. Kirsten?
Well, I think we actually already mentioned this. We may have further discussion after our executive session, so just confirming.
Yeah, thank you. And yeah, thank you
You-
for taking this up so quickly. I know that was a quick turnaround from, was it a week ago that we were in Senate Natural?
You guys were in Senate Natural on Thursday, we were in on Friday, so it's been a fairly rapid transition, and unfortunately, some of our board members and staff have caught the capital bug. I'm glad that you both have not yet. But you're welcome to wait in our comfortable waiting room, or Catherine, I can ping you when we're done and you can rejoin. But if you wouldn't mind taking us up on that offer, rejoining it when we come out, that would be fantastic and much appreciated.
Yeah, happy to stick around. Thanks.
Brooke?
We are going to be a while, just because we do have a number of things, lots of legislation, so we can ping you if you don't want to wait around.
I will take that up.
Okay.
All right, before we entertain a motion to go back into executive session. Kirsten, I see you have your hand up, but just let's take that, and then I do want to, since we have other public that's joined, also provide for them to comment before we go into executive session. So Kirsten, do you have a question, or?
No,
were
I
you
was just
gonna
gonna ask if.
Hold
we wanted
that
to go back
thought for
into
a quick
executive
second.
session, but yeah, you're right.
Annette,
pointing
I
out.
think you're the only one that, Annette, if you would like to say anything before we go into executive session, by all means, but.
Sorry, it always takes me a minute to turn my sound on. I have the same bug Janet does, I think. I saw you yesterday on Zoom. I thought, oh, she looks as bad as I do. But nothing, that didn't come out right. Anyway, as sick as I do. So this is sort of off topic, but the Zoom link didn't work in the agenda today. And it's the second time that's happened. And I let Maddie know, but I was hanging around for 10 minutes trying to get in. And so that's not good. And of course, Maddie is very good and sent me the information. Are you going to be discussing the recommendation you made to the Senate committee that I find very disturbing? And I see Thomas Weiss has filed comments about it regarding Tier 3 and allowing for a lesser review of the criteria and asking for a legislative change on that.
So I believe you're talking about S325, and that is the subject of one of the things that we have previously made a motion to discuss with council in executive session.
So I read Thomas's memo to you. Have you read it?
We just received it this morning.
Yeah.
So I can't
I
speak
just
to.
want to support. He actually did some research, which he is very good at, and he is making a strong case for why it would be a mistake to do that. I deal with, shall we say, less than forthcoming developers or developers who are good at finding ways to game the system. And I just see so many potential problems with what is suggested in that. I think that it undermines Act 250. And I did hear the reasoning for it when I was in the stakeholder group was that there's going to be so much opposition to Tier 3 that this will be a way of minimizing the opposition. That's the only justification I've heard for it. If there is another justification, I'd be glad to hear it. But I think that by itself is not going to minimize people's objections to Tier 3. I think that tier three, if it goes into effect in any shape or form, should have the same criteria. And if you review Thomas's reasons, he has actually looked at a number of cases to evaluate the issues that come up, and he says there's no way to predict what you would want to do. And so I will keep fighting to keep as much of Act 250 in its integrity intact. And so thank you for giving me the chance to say that.
Well, thank you, Annette. And absolutely, I don't think we are prepared to respond at this point. I think that's part of us going into this next session as a board for us to be able to listen, get additional information so that we can respond. So please stay tuned as always. And I do hope that you feel better too. Anything else from any members of the public, board, or staff before we consider a motion to go into executive session? All right, Kirsten, I'm ready if you're ready, I think.
Yeah, I'll just make a motion to return to the previously moved executive session.
I'll second.
All those in favor signify by saying aye. Aye.
Aye.
Looks like we have 4
Sorry,
ayes.
aye.
Unanimous, and we will see you back in a little bit, but I'll see you guys on the other side.
Maybe not yet, huh?
Hi, Charlie and Catherine. They are not out of executive session yet. But you're welcome to stay as long as you'd like.
Thanks.
And I think, was that Rachel? Just to let you know, I think we both have 3 o'clocks. So if there is any follow-up question, hopefully it comes soon.
Okay. Thanks for letting me know.
Yeah.
Hi, Rachel, we're back. Sorry, we didn't have a chance to tell you we came back so quickly. All right, so we're back out of executive session, and I think to report is we had some discussions about S325. We have our guests joining us again. Jenny, has she made it back? Yes, she has. All right, fantastic. Jenny, I think we have a few things that we want to share with our guests and sort of explain to them a bit of where we're at.
So to clarify for everyone, the black underlines and strike throughs are VAPTA, or the are the comments from Charles and Catherine, and then the red underlines and strike throughs are our potential divergences that we'd like to chat with you guys.
And so I'm happy to tag team with you, Jenny, and other board members feel free to chip in, but I think the descriptive language of substantial and sufficient we thought would be problematic, and trying to define those. And so we're recommending that they perhaps come out.
Just want to note that the substantial word is also in the housing goal, which is why I was here.
We know that, Charlie.
It gives those lawyers a term to argue about.
Yeah.
Amen.
When it's in the goal, it can't be argued as easily, but when it comes to actually it being reviewed in the plan, I think that's where they get their leverage. So those just a recommendation.
Yep.
The next, so Sarah, do you want me to dive in if that, okay.
Feel free to keep going.
So we had a rousing discussion related to the regional plan amendments as well as the minor future land use map amendments in subsection J of this. We didn't actually change the language too much, but we were trying to break it out to be a little more clear. As we see it, there's 3 things that could go through. There's if the legislature were to adopt as this proposal, which I think is following what you guys are doing too, there'd essentially be 3 different ways that the land use review board would review things. There would be like the full-blown initial regional plan, pre-hearing process, all that stuff. There would be this part, which is the regional, like the amendments, and then the subsection J part, which is those minor future land use map amendments for stuff under 10 acres. So we were hoping to clarify a little bit that the non-minor future land use amendments, those that are greater than what subsection J is contemplating, would fall under this review process so that you could amend your future land use maps without having to do the full-blown regional plan process. And I'm seeing nods. I just wanted to make sure that we're all on the same page with that.
I think that makes sense. I'm unclear why A would be changed to amend a regional plan or a future land use map, because if we change a future land use map, that's the same as amending our plan.
I think we wanted to make it very clear for anybody, like a municipality or anything like that coming to this, that both of these that both the future land use map amendments or the regional plan amendments are allowed here, even though understanding that an amendment to a future land use map is functionally an amendment to the regional plan because of the way that they are stacked.
Right, and I think, Catherine, it comes down to, what is it, that less than 10 acres of the minor map? And so that sort of called out as a separate. So,
Non-minor, however you want to.
correct.
And then, so just the process being in this first section, sorry, if I point at my own computer monitor, it's not like you guys know what I'm doing. There's the regional plan hearing, then it goes to the land use review board. Then, we would also, maybe this stays part of the section about standalone requests that also go to the land use review board after hearing. Then the board's hearing, and we were just filling out the language a little bit to make sure that we were really clear about which types of changes. And then this language up at the top about how the adoption comes down here and specifies adoption of a regional plan amendment, non-minor future land use amendment, or tier 1B status request or amendment, since those can come in originally or as amendments, shall not change the expiration date of the regional plan. So it actually retains all of the language that you guys proposed, just reorganized it a little bit. Janet?
I wonder, Catherine, if it would make sense to say, if Jenny, if you can just scroll up to the top of the page a little, to amend a regional plan, which includes a non-minor future map amendment, or could include, or something like that. Would that feel better?
Yeah, I think it would. We already struggle with people understanding that the future land use map is part of the regional plan and not its own thing. So
Right.
I don't want to inadvertently suggest it's its own thing by the
Right.
language. So thank you.
Right.
And that's where my concern was coming from originally.
Yep.
Okay.
No,
Would
you guys
need
have
to
limited
say
time.
that in that, would we need to say that in the previous paragraph, the introductory paragraph to this section, Jenny?
Non-minor future land use map amendments shall be processed as a regional plan amendment, or is there a way that you'd rather have that phrased?
Say as part of. But it's fine. Yeah, and just for the help of the conversation, I think both Catherine and I have to leave in like 5 minutes.
Yeah. Well, this is the hairy one. So
Yeah, gotcha.
Okay.
Great.
But you get the point. And so if you need to adjust any other things accordingly.
yeah.
Right.
So we already covered. So so this is that sentence that you guys were discussing earlier. I know that you've done a lot of wordsmithing, but I would humbly submit it is the intent that every town may have at least one village center. Would satisfy not requiring every town to have a village center and also allowing people to have more than one village center. And it would get rid of that word almost.
Okay, I'm seeing a head nod from Charlie, but
We're
I think,
any head nodding is not saying that's perfect. We're just
You're
acknowledging
Acknowledging.
receipt of the comment.
correct.
Yeah.
Understood. Did we have a question for them at the very end, or did we resolve that before?
I
I
think
just
we
want to
had
give space.
seen some language that, let's go down. It
Janet,
was,
you had a possible question towards the end, but you were talking about the 10 VSA versus.
Yeah, I know Charlie and Catherine were focused on just Title 24 because those were the early indications that Title 10 was closed. But at this point, it seems like it might be opened up a little bit too. And I wondered if you were supportive of the idea of identifying which four land use, future land use map areas are eligible for Tier 1B status.
Um,
Yeah, well, go ahead, Catherine. Did you have a thought?
I'm not sure was my answer to
Mm.
that
Yeah.
question.
Well, and I will say just more generally, we know, and Jan, I think you brought this to our attention before, that there are some links in Title 10 to these same issues. That, yeah, honestly, if the committee chair or the committee is open to those, I don't think it would hurt my feelings if you guys you threw some of those on the table at the same time if they were open to them. But it does start to, there's some other things too. I'm sure you're feeling like there's some things that aren't fully connected yet that need to be addressed at some point. Some of those I was like, it's just going to wait till next year, I guess. But sorry, Janet, you're muted.
Sorry, I don't want you to have to hear my coughing and then I forget. I don't want to push it because, yeah, it's a delicate balance, all these
Right.
negotiations. So, but at some point, statute should tell us the four areas
Yeah, and
that
I
are
think
eligible.
that would be a good conversation for you or another LUR member to have with the Senate committee chair, just to see
Okay.
their
Sorry.
thoughts.
Recognizing that we have our guests for 3 minutes, maybe 2. Is there anything, Jenny, that we forgot to cover? Did we cover it?
I think we covered everything that we thought pertained
Okay.
to us.
Do you want to stop sharing screens and we can see our
Yes.
friendly faces? And
Please.
Catherine, Charlie, do you have any questions or comments back for us before you jump?
Just appreciation for you, putting this on your agenda so quickly and responding, because, going through a deliberative process and engaging in the legislative process are not always compatible. So thanks for trying to make it work.
And did you have any concerns about the Act 174 language that we should be aware of?
I think we're okay, but Brooke, do you?
I just want to recognize what a work product this is. We appreciate the desire to fix and clarify, and we're not in any way trying to diminish that work. We're just trying to add to it collaboratively to make sure that we don't have any unintended consequences. So thank you very much for your continued involvement in this. It's really helpful to us.
You're welcome, and thank you all for the time to review this and for wrapping up by 3. Yay!
Well done.
All right, well, thank you
appreciate it.
guys. And with
Thank you
that,
all.
Thank you.
we're going to jump back into executive session. So, does anybody want to make another motion?
Thank you.
I'll make a motion to return to executive session as previously moved.
Second.
All those in favor, please signify by saying aye.
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 Or we'll go back in and we'll come back out again. All right. Thank you, guys.